Hello, everybody. I'm going to introduce you to, my name is Vince Lavori, and I'm going to introduce you here to Al Meyer. Al Meyer is an attorney who specializes in the health arena, and probably he's more well known for setting up relationships between doctors, chiropractors, and med spas or spas that want to become med spas or other, I guess you call it integrative practice relationships. And that's going to become bigger and bigger. If you don't know too much about the med spa industry, you should take a look because it's booming and it's going to get bigger and bigger. Now, most of these endeavors, from hormone replacement to Botox, they require a medical doctor, a DO, an MD, or a nurse practitioner, or allowed in states, or a naturopathic medical doctor in states where that is licensed too. They need a DEA license to get Botox, to get hormones, to do a lot of treatments, even some laser treatments, erectile dysfunction, sexual wellness. But these are all big growth industries, and why Al is such an attractive proposition as an attorney for many a doctor is because he's done this many times in many states. He understands most of the state rules, and he does have a flat rate, which is very reasonable too. And so this is not something he just started doing yesterday or is going to bill clients for research, because he has done a lot of this before, and if he doesn't know, he has the resources to find it out relatively quickly. What I want to do before we start, everybody, is we want questions, but we don't want any questions to Al is done with his presentation. So, but we would like you to give the questions as they come up. So if you slide your mouse to the top of the screen next to your microphone, there'll be these little green buttons that pop up. There is a chat bar. It's shaped kind of like a squiggly thing, like somebody speaking in a comic book, a little circle with a little squiggly thing going down. It's between the microphone and like a screen, and then to the right of that is like a person. So if you look at that little chat bar, you will see the ability, you can just basically open it up. So if you click on it, it's like I said, it's directly right of the microphone. All right, I'm going to turn this over to Al, but if you enter questions, I'm going to enter one right now. Test question. And then I'm going to mute myself and let Al go, and I'll unmute myself if I have a question. Al, you ready?
Yes, I am.
Okay. Ladies and gentlemen, Al Meyer.
Thank you, Vince, and good evening, everyone. And glad you can spend a few minutes with us. I know for some it's late, and for guys like me, it's after 9 o'clock, and it's almost my bedtime. But I'm glad to have some time to discuss integrated practices and basically how these things work. It's a relatively simple concept, but there's a lot involved, so it's not quite easy. But I'm going to try to give you some awareness and how we put these together and how I can help you get integrated practice going yourself if you so desire to endeavor in that. So just to let you know, this is only for informational purposes. This is not any type of legal advice. And if you do need legal advice, I ask you to contact an experienced healthcare attorney, and they can address your specific situation. So now that we got all the lawyer stuff out of the way, let me tell you just a quick thing about me. This is all I do. I do healthcare. I've been doing this for 25 years. I've set up hundreds of integrated practices throughout the country. And so this is, like Vince said, this is nothing new for me, and I don't have to research what's going on in these topics. So I've done it, I've seen it all, and I've welcome the opportunity to pass that wisdom on to you folks. So let's get started. integrated practices really involve the marriage of a lot of my clients are chiropractors. I also work with med spas, as Vince mentioned. I also work with acupuncturists to combine different disciplines to give much more of a continuum of care for a patient. So really, you know, a lot of my clients like to be a one-stop shop, and they come in, they will perform chiropractic, medical, physical therapy, and now with the advent of regenerative medicine and a lot of the med spa procedures, it can even evolve into some great cash-based services. So what is one of the most, the biggest hurdles that an integrated practice has to face is what's called the corporate practice of medicine doctrine. And that really means that a general business corporation that is run by a layperson or a non-medical doctor cannot own an entity that provides medical services. And when I mean corporate practice of medicine, that goes into other healthcare disciplines like chiropractic, dentistry, and physical therapy. The corporate practice of medicine doctrine is driven entirely by state law, and there is no federal corporate practice of medicine doctrine. And of the 50 states, it varies, could be very widely varied from and we'll get into this a little more detail, from a state where no one can own an entity to provide medical services except for a medical doctor, to the other extreme where anyone can form a corporation, rent an office, and hire a doctor, and they're in business. So let's look at a few of the different types of these corporate practice of medicine states. One is the single profession, and those are states where a licensee can only form an entity and practice one particular service. So when we're dealing with these corporate practice of medicine doctrines, I'm going to refer mostly to medical services. So when we have single practice areas and single professions, that means only a doctor, a medical doctor, can organize with medical doctors, DCs with DCs, and so on. Some of the more strict states are New York, North Carolina, and Michigan. North Carolina and New York are by far the most strict states when having to deal with the corporate practice of medicine doctrine. So if anyone is in New York or North Carolina, it's especially important that you talk with someone who is versed in how to structure these integrated practices in those particular laws. There are other states that permit a chiropractor or another licensed medical provider to own an entity that provides medical services. And states like Florida, here, my home state, a chiropractor can open up a corporation or an LLC, hire a medical doctor, and be off to the races to provide medical services that are within the scope of practice of a medical doctor. So there are a number of other states that allow that as well. And again, I can go through that with you and answer questions on your individual states. If you want to schedule a time to talk with me, we can address that individual issue. There are other states that have, like I mentioned, is on the other extreme, that have absolutely no corporate practice of medicine doctrines, and anyone can form an entity to provide medical services. Now, the most important thing is obviously that corporation is going to have to bring on appropriately licensed individuals to provide those services. I know it's, I'm Captain Obvious here, but some people may not get it. So when we're looking at some of these models, one of the simplest, if you're a chiropractor, I know we have some chiropractors out there, is having the chiropractor have 100% ownership. So in my state of Florida and a number of other states, a DC can form an entity. It can be a professional corporation or it can be an LLC, and they bring in the appropriately licensed providers. And typically, a lot of my clients will utilize a mid-level practitioner, like a nurse practitioner or a physician assistant, to be the primary provider of services. And in those states that regulate the practice of physician assistants and nurse practitioners, the medical doctor would have to enter into a supervising agreement with either of those two providers. Now, there's another system here where a MD and a DC can, or another professional can enter into a partnership to operate a integrated practice. One is where the medical doctor has to have the majority of ownership. And in those typical states, that's California is one of those, and I know there's a few others that require a medical doctor to have the majority of the ownership interest in a medical entity. And we can structure that in a couple of ways. One is the management company model, which I'll go into in a few minutes, and the other is splitting the ownership with certain caveats, meaning that the medical doctor can own the medical entity on paper, and depending on the type of corporation or business entity we form, we can make the agreement such that the MD really isn't, benefiting financially if they weren't putting up significant investment. So in states where we need to have the medical doctor own 100% of the medical entity, for states like North Carolina and Michigan and some others, what we do is we form a management services company. And a lot of my clients I do this for are chiropractors. I'll stick with that for an example, but you can plug in anyone as a business person, as a med spa owner, that will fit in this model. So we would put together a corporation, a limited liability company, and our management company would be wholly owned by that non-medical doctor. And this management company is going to provide all of the business and administrative services. So it would allow your medical people to focus on patient care and to not have to worry about those administrative and business burdens that come along with operating a medical clinic these days. And the most important thing is, if you're not a medical doctor and you are going to enter into this type of structure, we need to figure out how you're going to make your money. And you make your money through entering into a management agreement with the the medical corporation. And that agreement spells out the relationship between your management company and the medical corporation. And it provides for the medical corporation performing all of the business aspects such as bookkeeping, day-to-day administration, space and equipment. So everything that is involved in operating the practice is going to be covered by our management corporation. And what's going to happen here is the management company is going to collect fees from the medical corporation. And those fees have to be in such a way that they match up with the services that are being provided. And the reason why we have to do that is because in these corporate practice and medicine states, we have to make sure that this management company is not in control of the medical aspects and control of what the doctors may do and not do in their scope of services. Because if we have management fees that are exorbitant, regulators and medical boards and insurance companies are going to basically say this is a mere subterfuge of the chiropractor or the non-medical person, and they're in total control, and we don't think they're doing this the right way. And I've had a number of challenges over the years with state regulators, and a few of the things I'll go over in a minute have been through my experience with these people and how we can make sure that this is a viable enterprise rather than a sham like some of the people, some of the regulators may think sometimes. Let's talk about our MD involvement, and that's a nice segue into what I was talking about. The medical doctor has to be involved in what's going on in this practice. That person cannot be just a mere figurehead. And it doesn't mean that person has to be in the office 24/7, but that medical doctor has to know what's going on and has to know who the providers are and have his finger on the pulse of the practice. And to do that, we'll need to make sure that that medical doctor is engaged as much as possible through meetings, through consultations with mid-level practitioners, and other communication that's going to allow and demonstrate that this medical doctor is not just a mere figurehead and is involved in what's going on with the medical corporation. And that is vitally important because there's been some cases over the years that have charged one of these integrated practices for just being a mere subterfuge for the chiropractor to control the medical practice. And this was a pretty significant case years ago where a chiropractor entered into one of these ventures with a medical doctor who owned, I think, essentially 26 other medical clinics. And with those 26 clinics, that doctor didn't appear at all in any of these clinics. There were no meetings, there were no communications, and the court came down and said, you know, this is just a sham and you're in control of this and this doctor has no say in what's going on. and proceeded to enter a judgment against the doctor for several $1 million. I've seen insurance companies, now you guys may not be dealing in insurance, but I've seen insurance companies sue these integrated practices for money that they had paid and wanted to get refunds because the bills were submitted from an illegal operation. So my point being is it's very important if you're going to enter into one of these integrated practice structures and you're in one of those states that you need to have the medical doctor own 100%, is that medical doctor needs to be on board and needs to be involved to a large degree. We went through that. And some of the things that we would have the medical doctor be involved would be attending board meetings, input with large capital expenditures, like say you were doing stem cell injections and you wanted to have guided injections and you bought an ultrasound machine or maybe a C-arm. Communicating with the mid-level providers, reviewing financial statements, reviewing charts. All of that lends itself to making sure that this medical doctor knows what's going on within the practice. So a lot of times, and on this slide, I mentioned unwritten regulations or interpretations of regulations. And I found out over the years what may seemingly be allowed under different laws and regulations may be prohibited or frowned upon by regulators. So it's important that you do have somebody that is really cognizant on kind of those double secret regulations that may have a profound impact on how you would provide your service. For example, and this is probably in a more positive light, there's a state where if you look at the current regulations and some case interpretations, you would think that no one but a medical doctor can own a medical corporation. However, in talking with the medical board and the chiropractic board, they really aren't enforcing that, and basically have said that as long as no one else is interfering with the medical decision-making of the doctor or a mid-level provider, then we're not going to have a problem with it. So you really got to make sure that you're aware of some of those kind of unwritten or subtle regulations that some of these states may have. And again, I'm going to read this. I don't like reading slides verbatim, but this one's important. Operating a medical practice without significant MD involvement may look in the eyes of a state and federal regulator as a mere ruse to permit a non-medical doctor to provide medical services. The MD is the legal owner of the medical corporation and must actually assume that role. And that's for the benefit of you as a business owner and also your medical doctor, because your medical doctor can be at risk of having discipline on his license, and certainly we don't want that to occur. How much time do I have, Vince, if you're on? I'll just be a few minutes, so we can.
Time. You've been on for, we figure these go about, 45 minutes, so we're just at 30 minutes.
Let's look at a few minutes. So let's look at a few other things. And I know a lot of you are doing mostly cash-based, but if you are doing Medicare, and there's these wonderful laws that are always going to be with us, the anti-kickback statute, the Stark Law, and the False Claims Act. These are laws that are somewhat complicated, but if you're paying someone for referrals, you're getting free rent, something that could be as benign as if you're doing lab work and you get free specimen vials from a lab, those could be seen as kickbacks. And even though I'm focusing on government health programs here with kickback statutes in the Stark Law, there are states that have their own laws that are similar to this. So, and I know here in Florida, we have similar statutes that apply to any type of health service and also apply regardless of the payer source. So we have to pay attention to these kickback laws from both the federal and state perspective. Usually these laws are more of an intent-based statute when you're looking at the anti-kickback statute. But when you're kind of turning your head, or just as this guy is putting his head in the sand, that could be seen as an intent to allow or acquiesce to kickback. So you really have to be aware of what's going on, and and also importantly, what the folks in your office are doing. Because if you know but you don't want to know kind of thing, you can end up in a lot of trouble. The penalties for these are very severe. You could be looking at significant fines, prison time. You can be excluded from the programs. And the penalties for kickbacks can include up to $10,000 or $50,000 per act. And those damages can be trebled, which is multiplying it times 3. So I'm going to give you an example here of how a mere $20 error for 100 claims can lead into a multi-million-dollar penalty. So we have a physician he overpaid $20 for 100 claims. Okay, big deal. That's $2,000. Well, if you take that, multiply it by 3, it's $6,000. Now, the penalties for each violation, we have 100 violations at the minimum penalty of $11,181. We have over $1 million. If the maximum penalty is assessed, the penalty is up to $2.2 million for a $2,000 mistake. So it's important that you really make sure that in your dealings with laboratory companies, with suppliers, with DME suppliers, that you make sure that there is nothing of value, and it doesn't necessarily have to be cash, that there's nothing of value exchanged between the parties. And again, a lot of you guys are going to go with cash, so this might be a bit redundant and maybe not applicable, but it's probably good to mention it anyway. Proper evaluation and management codes. You got to make sure that you're matching up your E&M codes with the actual services being provided. Documentation is going to be important no matter what you're doing and no matter who is the payer source, because you want to make sure that if you're dealing with Medicare or insurance, that your documentation tells the story of what the patient came in there for, what their problem was, what was the diagnosis, what was the treatment plan, and how was the treatment plan administered. And if you're not doing an insurance-based practice, and if you're dealing with a cash-based service, it's still very important to have good documentation in case there's a possible malpractice claim, or what is more common, a patient doesn't like what was received. They may have gotten an outcome that wasn't expected, or that was not what was promised, and they come back and they want to sue you. And if you can show that you've done all of these steps, then, you know, if this person came back to sue you, you would have a much more of a defensible case. So it's important for documentation, no matter, you know, what type of service you're doing and no matter who's paying for it. So now we get to the point where, okay, I have a cash practice, so it really doesn't apply to me. Well, now, as I mentioned a moment ago, yes, it does. And we do have state fraud and abuse laws. Florida, if we have any folks here in Florida, our state kickback and self-referral laws are in a lot of ways more strict than the Medicare laws. Another thing to keep in mind, a lot of people don't consider this, is that in your cosmetic or med spa or stem cell procedures, the malpractice risk is rather low. However, when you're providing these services, you're entering into a contract just as if you were doing any type of business deal. And if you promised to deliver a certain outcome and it was not delivered and the patient did not receive that, then a patient can go back and say, you know, I paid for this service, I didn't get it, you told me I was going to be without pain, and I'm still in pain, or I have an infection, and I want my money back. And those incidents will cause you lawsuits and worse. And I'm defending a number of these cases now where a stem cell patient went to a state licensing board and complained about the advertising, complained that they didn't get what they paid for. And so I have a client who has to defend from an allegation of false and deceptive advertising. I had a couple of my chiropractor clients be charged with practicing medicine without a license because they were giving consultations that they probably weren't supposed to be doing. So even if, the moral of the story here, even if you have a cash practice, you're not immune to any of these problems. And some of the things that I'm seeing with stem cell practice are, again, when a chiropractor is meeting with a client and discusses the treatment and basically says that, well, yeah, you can benefit from stem cell. You've got regenerative disease in your knee. You got osteoarthritis, and that could be construed as a non-medical doctor providing a medical diagnosis. So much care has to be taken with that. Some of you that are doing stem cell now or plan on it, the FDA is regulating this a lot more, and I don't want to discourage you from doing this because all this, I'm not discouraging you from doing this because all of this can be overcome, and we can put this together in such a way that you're not going to have these issues. But I think, and Vince wanted to bring me on here to show how these are structured and look at some of the legal pitfalls so you can make sure that you are aware of what's going on and aware of what you have to do to set this up in such a way that you'll be successful and you won't be getting knocked on the door from Medicare or from a licensing board or any other type of regulator. So,
yeah, I think that's an important part. I just want to point out, Al, that this is it's funny that you're bringing this up. One of my good customers, now friends, goes back many years, is how I got into this kind of industry. He ran into he ran into the lovely what do you call it, scope of Blue Cross Blue Shield. He was involved in an MSO where there's a bunch of chiropractors, and they were billing insurance for blood tests, and they're getting outrageous rates. And 2 years later, they want their money back, and it was a couple $1 million.
Yeah, and it's happening more and more because the insurance companies are looking at, they're trying to find every angle they can not to pay, and I'm seeing that a lot down here with auto carriers, or PIP carriers. State Farm and Allstate have gotten wind of some of these integrated practices and have tried to go after them, basically stating that they are shams and not controlled by a medical doctor and practicing, and you have a chiropractor engaging in practice of medicine and violating self-referral laws. So they're just throwing everything they can at these providers to not pay them. So, and I guess with Jerry Springer here, my final thought is to just make sure I would love to work with all of you. I've done this for a long time, but make sure you have someone that you're dealing with who knows how to set these things up correctly and can work with you throughout this whole process, not just in forming a corporation. Anybody can do that, but in guiding you in things that you may not think of, but I've seen it, and I can tell you beforehand what can happen to you if you do something or not to do something. So I hope it helped. I hope you got some information. Like I said, I don't want to scare anybody away. This is a great model. You could have great success with it. It just needs to be, from a legal and regulatory standpoint, you really need to take those steps to make sure it's set up properly in the beginning. So you don't have to go down the road 2 years and all of a sudden you realize you didn't do it right, and you have to go back and redo everything, which could put you, number one, behind business-wise, and also can cause some trouble with insurance companies and licensing boards and people we really don't want to talk to on a regular basis. So I think we have time for questions, and I'll be happy to answer them. My contact info is up here at the top, right here. If you want to shoot me an email or give me a call, I'm happy to set up a consultation with you. I don't charge for initial consultation, so feel free to get a hold of me, and I'll be happy to talk with you.
Al, the first question that I want to, it might even be a shameless plug here, but so Al does a flat rate fee, which if any of you have dealt with lawyers, it's a great deal if the attorney and the patron are kind of on the same page. What do you typically charge to set up
depending on where the state usually runs between $3,000 and $4,000 plus state filing fees, and that does include the documents, and also includes you picking up the phone and calling me or emailing me without the meter running. And the reason I've done this is that this is new territory for just about everyone. And I don't want to have someone, who's fee conscious not to call me up and ask questions for fear that the meter is going to be running. So I do that just so, I make sure that my client is getting things set up the best way we possibly can.
Okay. Anyone else? Wow, you must have done a pretty good job.
Either that or it's getting late.
No, I don't know about that. I've got a list of them. I know I've talked to you before, but I know California is a 51% doctor ownership state, but I had a doctor that wants to be on this call, and I guess if he's not here, Nevada. He's licensed in both California and Nevada. How is Nevada set up?
Nevada is one of those states where the medical doctor has to have the sole ownership, 100% ownership.
And when you set these up, the way like say a chiropractor would earn their money would be how admin fees or typical costs, or
yes, that would be through the management fees that would be paid from the medical corporation, and what I help put those together. I give I give everybody a 5-page summary and how to line item the different services that the management company would be doing, and really how we can put that together so it is a viable business opportunity, and we can make sure that as much money as possible passes through to the management company, and still keep us out of trouble.
And is that the same way you would do it in like California?
It all depends. I usually do it that way in California because of the fact that the medical doctor has to have 51% ownership. There's been instances where a chiropractor and a medical doctor wanted to be true partners, and so we'd have to be a little more creative with that 51-49 to make sure that each partner is going to get their equal share. So I've done it both ways.
And I know what's going on here. Look, everybody's still on the call. I'm glad you pointed out what can happen if you do things wrong. I know a few people even on this call that have been associated with entities that have done things wrong, and then me, I'm dealing with companies that are doing everything right, and it's a great business model, particularly when you've got a chiropractor seeing 100+ patients a week, and a doctor that's in that insurance mode getting $60 a patient, and then wanting to get $2,000 a stem cell injection or something.
Exactly.
So Bruce Feldman just asked a question on text on the chat. Let me look at it real quick here. Are we able to set up a smaller medical spa with a larger chiro practice? And then there's another question I missed. So once you answer that, then we'll get to the other one.
Okay, I'm sorry, I didn't quite hear that question.
It's are we able in New York, to set up a smaller medical spa within a larger chiro practice?
New York is one of those states that's funny, and unfortunately, to put together these integrated practice models, it's a lot more difficult there. But I think it all boils down to what is the scope of practice that is needed to provide these services. So if you're bringing a med spa in and you have services that require a medical doctor or maybe a nurse practitioner, then we can put together that similar MSO model. But there's a number of things in New York that we have to be careful of as far as how the management fees are being paid and the scope of services that the management company can provide to the clinical entity. So yeah, if you're interested, feel free to get in touch with me, and I'll be happy to talk to you in more detail.
Okay, so that's Bruce. We'll make sure he has your contact information. But I actually have another sub on that before we get to the Arizona question. I've been to one actually in New York where it was originally, I don't know if it was the chiropractic clinic or some other clinic, but they subdivided the medical board. So they actually took that lease and they created a whole medical office, which was the spa inside of the clinic, which I think was chiro or maybe physical therapy. I don't know. But they actually had two separate offices in the office. But it was a and that's how I would recommend doing it in some of those states. But you have the issue of ownership, which is the biggest thing that we need to address and how to run that so we don't get in trouble and we can do a good job for our patients and make some money at the same time. And the next one is in Arizona, where a chiro-owned clinic having an NP with a DEA license is enough, or does there need to be a supervising MD? I'm not clear on that. I can send my answer. They have a
I believe.
Medical doctor.
Go ahead. I'm sorry.
I was just saying there's a naturopathic medical doctor in Arizona, and they can perform all these procedures.
Yeah, their scope of practice in a number of states is pretty broad. A lot of the western states, the naturopaths can do a lot more than what they would be able to do, here in the east and the south. So, and nurse practitioners in Arizona, I believe they can practice independently in Arizona.
Yeah, I can too. I got a link I can send everybody, or Brock does, that talks about which states nurse practitioners can practice without supervision. Brock, if you could send that to everybody, that would be great. Well, I think that's it. It's getting late. We're coming up on 50 minutes. Al, I appreciate your time. And this was
my pleasure.
It was really informative, and I like the fact that you had your slides and you're all perfectly organized. So I think you've done this before.
Yes, I have. But I enjoy doing these things, and I hope it was helpful for everyone. And again, I'm happy to spend some time with you to discuss this. And if you're interested, of course, I'd love you to come with me and let me help you. But please get the advice of an experienced attorney. There's not a whole lot of people that do this kind of work. So don't be fooled when you have someone that says they can do it and they've never done it before. So just make sure if you're looking at somebody, ask them how many of these they've set up and where have they set them up, and how much research they're going to have to do. If they have to do a lot of research, then you need to go somewhere else. But again, good luck, and I hope to talk with all of you very soon. Have a great night.
Thank you so much. Thanks for everybody for tuning in, and thanks so much again, Al. This was fantastic.
Great. Thank you.
Good night, everyone.
Good night.